Hey, welcome once again, Employment Law Show. John Scholes, Lior Samfiru. We are ready to go. We hope you are as well. Busy show today. I'll give you the information right away. 1-855-821-5900. Help at employmentlawyer.ca. Reach out anytime. We'll have that across the bottom of the screen over the next 30 minutes. So if you missed that, you will have a chance to catch it and write it down. We'll get to some phone calls from our radio show. If you have not caught that before, employmentlawyer.ca for a location where you can catch our radio show, which I think is going on 8 or 9 years now. It's been a while, so we're proud of it. And that's an hour-long employment law feast every week, so check that out. We got the week that was coming up here, Laura, first, but I wanted to mention duty to accommodate in Canada. What is that all about? We'll get to that in just a bit, but you have the floor, my friend. How are you?
Well, this certainly is a televisual feast, is what I would call what we do here on the show. But I am really glad to be back, Johnny. I'm really glad to be talking about employment law. It's been a busy number of months. I've been practicing employment law for about 18 years. I don't recall ever in my career such a period of time with so many issues, so many questions, so many things changing quickly. So I'm very happy to have this forum to be able to educate and inform everyone about workplace rights, about employment law, about your severance, about your layoff, about the termination of your employment, accommodation, you name it. That's what we do on this show. These issues are always important, but they've never been more important than they are right now. So we'll cover a lot of topics. And if your topic, your issue or concern is not addressed, we'll give you my contact information so that you can reach out, so that I can answer your questions and talk privately about what worries you. There's answers and solutions, I assure you. But as John said, I always like to start with the week that was, a situation that came across my desk very recently. So I spoke with a gentleman just a couple of days ago where he was called back to work from his COVID layoff a couple of months ago. When he was called back to work, his employer brought him back on a part-time basis, but he said, no, don't worry, this is only temporary. Our plan is to bring you back on a full-time basis and to make you back full-time as soon as possible. Well, a couple of months passed. This gentleman has been working part-time now. He had been full-time for over 12 years prior. He's asking his employer, well, okay, when am I going back to full-time? I need to be earning my full wage. I can't live off of part-time wages. And his employer finally said, we don't see the business improving enough to be able to have you full-time, so we're going to have to keep you part-time. So he called me, and he wanted to know, what are my rights? Now, John, you know that usually when I tell these stories here on TV, I always have a happy ending. I have a solution and a way that we resolve the problem. Well, this one is the exception. Unfortunately, I did not have a solution for this gentleman, and the reason for that is because when he was brought back part-time, because he accepted that, now he is stuck in that role. So that means he really can't do anything. And if his employer keeps him on a part-time basis forever, he cannot do anything about it. That's a terrible situation to be, because now he's going to have no choice but perhaps to look for another job or continue working part-time, not earning enough. And I'm bringing this up today here to remind you that if your employer changes the terms of your employment, if that's what happens, you go from full-time to part-time, or your pay is reduced, or your shift is changed, any significant change, if you accept that, you're then stuck in that role, meaning you can't do much about it, you can't get severance, and your employer can keep you in that role forever. The other option that you have, if your employer changes the terms of employment, is to say, no, I'm not accepting it. And if your employer goes ahead anyway, you can treat that as a constructive dismissal. You can leave with your severance so that you're not stuck in that new role forever. If he had called me as soon as that change happened, as soon as he was reduced from full-time to part-time, I would have been able to help him. I would have been able to get him his severance. Now, after a couple of months, he's stuck. Please don't let that happen to you. If your employer changes the terms of your employment, if you're reduced to part-time, if your compensation is changed, you have to act on it quickly. Contact me as soon as that happens. Please don't sit on your rights.
He waited a couple months, so he ran out of time. What kind of window are you talking? What are we max? A couple weeks, maybe?
Yeah, even if it was less than a month, I'd feel pretty good about it. Right. If he tried it for a couple of weeks, or he was hoping for a couple of weeks, 2, 3, 4 weeks that he'll be brought back to full time, I could have done something. But after a couple of months, he's stuck in that role, and he potentially now has no choice but to leave without compensation. That's not a good situation to be in.
You want to reach out anytime, as mentioned, 1-855-821-5900. Employmentlawyer.ca is the website. Catch a radio show near you, and we take the phone calls from the show, play them back here, and we talk about them. First call for today, Lior, is coming up right now.
A buddy of mine asked me to call in. He worked for a trucking company for 4 years. He's 54. A couple of weeks ago, they called him in and they fired him, said that he ran a stop sign, but they didn't give him a chance to present his side of the story, so they fired him. So then he said, well, you guys owe me severance. And they said, no, we don't owe you severance because we fired you with reasonable cause. And he said, no. They said, well, it doesn't matter anyway. We're governed by federal law, not provincial law, so we don't owe you severance anyway.
Trying every angle.
I'm chuckling here, not because there's anything bad about this question, because I see this so often. And, you know, we've spoken before, you and I, about some industries being kind of the Wild West. Well, trucking is another one of them, believe it or not, where employers and employees often don't appreciate their rights and their obligations. So let's break this down a bit. First of all, did he in fact run a stop sign? Well, obviously, if he did, that's not a good thing. But even if he did, that in and of itself is not cause for termination. Remember, you can only be terminated for cause if you've done something so bad that it's impossible to continue employing you. So either you did something really bad, or you've done a lot of things and your employer warned you and they gave you chance after chance and you're not getting it. In this situation, if this is an isolated incident, absolutely that's not cause. That's assuming he even did it, which he says he may not have done it. So remember, it's very difficult to be terminated for cause. Now, this whole notion that as a federally regulated employer, they don't have to pay severance, that's ridiculous. That's false. A federally regulated employer absolutely has to pay severance. In fact, they have to pay the same amount of severance as every other employer. So, John, we know that this person was wrongfully dismissed because it's not cause. He is owed severance. So rather than me just tell you how much severance he's owed, let's take his information and let's plug it into pocketemploymentlawyer.ca so that we can do that severance calculation and see how much he's owed. So we know that this person is a truck driver. You see that on the screen. He's been there for 4 years, 54 years old. He was not given any severance because his employer said, oh, we don't have to pay you. Well, you see right there on the screen, he's owed about 6 months' pay. 6 months' pay. Depending on how much he's earning, that's certainly going to be tens of thousands of dollars. So he was wrongfully dismissed, and it's important. Federally or provincially regulated, it does not matter. And just because you did something wrong, that does not mean that's cause for dismissal.
Why do those two terms keep coming up, federally or provincially? Wherein lies the difference? Why do they matter at all?
So it really doesn't matter in reality. Now, your minimum termination entitlements may be somewhat different if you're federally or provincially regulated, but it doesn't matter. Your full entitlements, what we call your common law entitlements, are exactly the same. They're based on your age, your position, and the length of your employment, not the type of regulation that your employer has. So if you've lost your job, you're owed severance. You go to pocketemploymentlawyer.ca to find out how much severance you're owed. Works just the same for provincially and federally regulated employers.
There's another way for you to reach out. Even still, terminationquestions.com is a great resource. You can leave your questions there, either Lior or a member of the team. We'll get to it and answer it. We'll get to one for the show now, Lior. I'll read this to you. This one comes from Tom. He says, before bringing me back from a layoff, my boss wanted me to accept a new contract that changed my employment after 12 years to part-time status. When I refused to sign, he said that I'd effectively resigned. What about that?
Well, this is exactly what I was talking about in the beginning of the show. What that person that called me initially should have done, should have said, no, I am not agreeing to this. No, I'm not going to allow you to reduce me from full-time to part-time. Why? Because you don't want to be stuck in a part-time role forever. So let's be very clear. This person that said, no, I am not accepting this reduction, did not resign. Remember, your employer doesn't get to decide if you've resigned. You're the only one that gets to make that decision. So if your employer says, well, unless you do this, you've resigned, no, nonsense. They can't do that at all. They can say, if you don't do this, I'm going to let you go, but that's not a resignation. So this person was absolutely right and well within his rights to say, I'm not going to go back, or I'm not going to go to part-time. His employer now terminated his employment, so he gets severance. The good news is that the severance that he gets is going to be calculated based on his full-time hours. If he accepted a reduction to part-time and then he was let go, the severance he would have received would have been calculated on his part-time hours. That's another reason why you don't want to accept a reduction to part-time or a reduction in your pay. So in this case, no worries. It's not a resignation. It's a termination. You're owed severance, and he did the exact right thing by not allowing his employer to reduce his pay.
You know, I think too many people fall into that trap and they're told, you know, resign or else, and they get scared and they do it because they think there's some record of employment out there that's going to show that they got fired, so they better resign because the optics look better. But that's not true, is it?
It's not true at all, not at all. There's no big database that's kept in terms of why someone left their job. There's no, thing you can find on Google as to, hey, why did John Scholes leave his employment? None of that exists. So the only thing, a record of employment, that document is relevant is for applying for EI. And by the way, if you've resigned, you're not going to get EI. That's why there's another reason. If you're not going to work for a company, you're better off to have your employment terminated. You get your severance, you get your EI. Do not resign unless you resign voluntarily.
Let's take a short break. We'll get into the duty and to accommodate and signing a new contract after a temporary layoff. That is all on the way. In the meantime, the phone number, 1-855-821-5900. Help at employmentlawyer.ca. Lots more coming up. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. John Scholes here, along Lior Samfiru. We are going to discuss something called duty to accommodate. What does that mean? Well, let's get right into it, and we'll find out. You want to reach out in the meantime, terminationquestions.com. You can always call Lior and the firm, 1-855-821-5900. First one, pal, what is the duty to accommodate? What is it?
This is a very important topic because the duty to accommodate is one of the most fundamental, and I would say one of the most important obligations that an employer has under our employment laws. So the duty to accommodate arises from human rights, from our human rights legislation. It's the same in every province. And the duty to accommodate is an obligation that an employer has to provide assistance and support to employees in certain situations. Probably the most common form of duty to accommodate happens when an employee has a medical condition and they need some help, some assistance in terms of going back to work. The accommodation may be the form of modified duties or modified hours or the ability to work from home. The duty to accommodate is that obligation that an employer has to provide that assistance. It's a very important obligation, and it's an obligation that many employers don't understand or perhaps don't take as seriously as they need to. So what we want to remind here, everyone, is that, yes, there are many situations where you are able to, as an employee, to go to your employer and say, employer, I need to be accommodated, I need your help, I need your assistance, and your employer then has that legal obligation to make it happen.
At what point does that get triggered? Is once there's a doctor involved or a medical team?
Yes, so when it comes to your accommodation for medical reasons, it starts and frankly ends with a doctor's note. So if you need accommodation, maybe you need to work shorter hours, or maybe you need not to be lifting heavy loads. If you have a doctor's note that says that provides what the accommodation is, that's when the obligation shifts to the employer to make that happen. So usually it would not be enough for the employee to say, hey, employer, I have a medical condition, so I need to work part-time because of it. That has to come from a doctor. So I would urge every employee that needs accommodation to get that information from the doctor, to be as detailed as possible as to the type of accommodation, the different options, even for how long the accommodation needs to happen. Get that information from your doctor. Once you do, you are protected. The law then says, employer, take a step back, figure out how to provide that accommodation. It's your duty and obligation.
The flip side is, when does the employee not have the right to be accommodated? When does that happen?
So generally, accommodations is something that the employee cannot help. So if there's a choice in the matter, usually an employer does not have to accommodate. So if, well, I don't really like this job, I'd rather be in another job, that's not enough to be accommodated. If it's for medical reasons, I can't do this job, but I can do this other job, then yes, the employer has to accommodate. Usually, accommodation has to be tied to a human rights matter. So tied to a disability, tied to religion, tied to your family status. So the most common types of accommodation, as I said, medical accommodation, we talked about that. Another common one may be for religious reasons. If, for example, you need to be able to leave work, let's say early on a Friday in order to go to mosque or to go to synagogue, if that's a legitimate accommodation that you need for religious reasons, the employer has to make that happen. Family status accommodation. If you have childcare responsibilities, an employer may have to accommodate you to allow you to meet those obligations. Maybe that means giving you some flexible hours or allowing you sometimes to work from home. If it's tied to a human right, then the employer has to provide that accommodation. It's not enough for you to simply say it, but if there is a legitimate reason that you can corroborate, then that obligation, the duty to accommodate, exists.
You wonder if you qualify for that duty to accommodate, just reach out anytime, help@employmentlawyer.ca. We're talking about the duty to accommodate in Canada specifically. How far, I'm sitting here as an employer going, okay, I get that I have an employee who has a doctor's note. How far do I have to go as an employer to accommodate an employee?
That is always the question that I get from both employers and employees. Okay, we know now we have this duty to accommodate. We know it's an important obligation, but how far do we have to go and how far is too far? So keep in mind, John, that because it's such an important duty, it's expected that even if it's not easy to accommodate, the employer still has to accommodate. Even if it's a situation where it costs some money and it really is a bit of a headache, the employer still has to do it. We call this in legal talk accommodation to the point of undue hardship. What that means is even if it's hard, you have to do it. Now, there is a point when it becomes too difficult or too expensive. Then at that point, yeah, the employer does not have to go that far. If it's a huge cost involved, if it's going to disrupt the operations of the business, if it's going to put someone else out of work, yes, the employer does not have to go that far. But yes, you are expected as an employer to accommodate even if it's difficult. And John, I've seen this happen so many times, more times than I can count, a situation where the employer does not go far enough. They'll accommodate if it's really easy, but they don't want to accommodate if it becomes a bit more difficult. So no, that is a human rights violation. That's a failure to accommodate. So if you are in a situation where your employer won't accommodate you, your employer refuses or says it's too much, it's too difficult, reach out to me. Let's talk about that. Let's figure out what really is going on and let me help you. That duty to accommodate cannot just be ignored easily.
The point of undue hardship, does that goal line change depending on the business? Meaning if I run a small pizza shop with 3 people as opposed to a multinational corporation, they have better resources, more money, I would assume they could probably go further to accommodate, or that doesn't matter?
No, it absolutely matters. It is expected for a large company that they'll go even further to accommodate because they have many roles available potentially. They have more resources. They have more sophistication and more abilities to make things happen. So yes, a company like that, a large employer, is going to be even more on the hook for accommodation. Whereas if you work for a small mom and pop shop with 2 employees, there just may not be a lot of things the employer can do to accommodate. So yes, the bigger the company, the more resources, the harder it is for them to say, oh gosh, this is just too much.
So I'm listening and watching this show today going, you know what, that's me. I need to be accommodated, but my employer refuses to do so. What do I do?
Well, it's very likely, and this is very common, that if your employer won't accommodate you, that is a human rights violation. That's illegal. Like I said, that's one of the most fundamental rights that all employees have anywhere in Canada. So I see this very often when it comes to medical conditions, where an employee is off maybe for medical reasons, wants to come back and says, I can come back, but I need modified duties or modified hours. And the company says, oh gosh, no. We're not going to do that. We're only going to bring you back if you can work full time. Wrong. That is illegal. So if your employer won't accommodate you, if your employer won't provide the support and the help that you need, reach out to me. Oftentimes, a letter from me reminding your employer of its obligations can resolve that issue. If we need to, we can pursue a human rights matter, but your employer cannot simply ignore that duty to accommodate. Let's talk about it. Call me and I'll help you.
Check out the website, employmentlawyer.ca. Anytime there, you will be able to catch a station to catch our radio show, which has been going on for years and years. We got a ton of phone calls every week. People just want to know this information. And we'll get to another call here on this show. Now, Lior, call number 2 for the day is coming up.
I'm being transferred, I guess, changing companies, not really voluntarily. My responsibilities are getting a little bit more, but my pay isn't going to be affected. But in essence, I'm all of a sudden being forced to sign documents to say that I'm now working for a new company with a new employee handbook that talks about dismissal without severance. I'm just wondering, should I not be getting severance right now, or as opposed to them carrying over my time served, is what they're trying to say?
Good time to call.
It's a great time to call. You know, there's a lot of things here that probably would require a bit of more of a in-depth discussion, but generally speaking is this. Regardless of how your employer chooses to organize, if they have you working for company A or company B, whatever, the key here is this. The key here is your job being changed. So this person says, well, they're changing my job, but they're also asking me to sign a document that gives up on my severance. No, don't ever do that. Your employer may use the excuse of a transfer, for example, to try to get you to sign a document that gives up on severance. So think about it this way. You sign this document giving up on severance. A month later, they let you go. Now, instead of getting 24 months severance, you could be limited to your minimum entitlements, which could be as little as 8 weeks' pay. So the answer for this person will be, no, I am not agreeing to anything that's negative. I'm not going to sign a document that gives up my severance. I am not going to agree to just change my terms of employment. And his employer cannot force him. If they choose to let him go, they have to pay his full severance. But isn't that a lot better than signing a document, then being let go, and then realizing, wait a second, you gave up your severance rights? And that's true for everyone out there. If you're already employed, if you have a job, and your employer wants you to sign a new document, an employment agreement, a new handbook, be very careful. There likely is terms or are terms in that document that could affect you significantly. Maybe terms that limit your severance. Maybe terms that allow the company to reduce your pay. Don't just sign a document without knowing what it actually says. And if you don't know what it says, if you're not sure what it means, send me a copy. Let me look at it. Let's have a discussion, and I can explain it to you exactly what it means.
Good time to throw the email address out there. Again, that's help@employmentlawyer.ca if you want to do exactly that. We'll take a short break and get into terminated by way of restructuring. We'll tackle that one after we come back. Employment Law Show. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. We also have a radio show, the Employment Law Show. Go figure. The title's working on all formats. We take a ton of phone calls on it. Lior, we'll get to phone call number 3 right now.
Recently, my wife, she was at her work for like 3.5 years. She was on light duties. She got her letter saying she could go back to her regular duties. The day following, they let her go. They basically said that they were restructuring and her job was eliminated as such.
How long has your wife worked there for?
About 3.5 years.
How old is your wife?
She's 40.
So right away, and this touches very nicely on the duty to accommodate that we were talking about before the break. Right away, the concern here is this. You've been off on a medical leave, you're excited, you're ready to come back, you worked hard to get better, you call your employer, hey, guess what, employer, I'm coming back, but I need some modified duties. The answer is we're restructuring, so we're letting you go. Well, again, I don't know what exactly is going on there, but it sure sounds like they're letting her go because she needs accommodation or because she took a medical leave. And if that's what happens, that's a human rights issue. Okay? You cannot be let go because you took a medical leave. You cannot be let go because you need accommodation. That's illegal in a number of respects. So right off the bat with this particular person, I'm very concerned that she is let go conveniently for restructuring when really she's let go because of the accommodation issue. So right now, right away, we have a human rights issue. Beyond that, of course, in addition to that, we have the issue of severance. So there's a tool that I created. I mentioned this earlier on the show. It's called pocketemploymentlawyer.ca. Now, it does a couple of things that are relevant to this caller. Number one, it allows you to determine whether, in fact, there is a human rights violation going on. It does that, again, anonymously and free. And of course, as we know, it also allows you to calculate severance. So we talked about the human rights violation. Let's see how much severance this person is owed. So I'm going to plug her information to pocketemploymentlawyer.ca. We know she's been there for just shy of 4 years, 3.5 years. She's 40 years old. She was let go. You can see she's owed as much as 4 months' pay. Okay, 4 months' pay. That's, by the way, before we even touch on the human rights issues. She could be owed much more because of the fact that she was let go coming back from a disability. So that's why it's so important and so easy to go to pocketemploymentlawyer.ca. It's like having your own lawyer with you, anonymous, free, easy to use. So check it out.
And there is a contact button at the top right if you want to carry forth and get a hold of Lior and a member of his team, no problem. Also, terminationquestions.com. We went to it earlier today, and I'll get to another one from it here, Lior. Again, terminationquestions.com. Leave your questions there and get that answered really quickly. Cecilia writes in, says, my employer has always paid me extra for the odd overtime hours I've worked as required. They came to an end once COVID-19 hit. They will no longer pay me a premium for working extra hours, even though my increased workload is forcing me to work overtime every single day.
So hopefully our regular viewers know that an employer does not have a right to make significant changes to terms of employment. That, of course, includes pay cuts. Well, if you think about it, John, what's happening here is she's going to be taking a pay cut. Her employer decides, we're not going to pay you for overtime the same way. In other words, we're going to pay you less. And that is a change. Whenever an employer touches someone's pay, that is a big deal. One of the most fundamental terms of employment is our compensation, our pay. So the question now becomes, how much is she actually losing? Usually, once we go beyond 10%, we're in what we call constructive dismissal territory. So if it's less than 10%, there may not be something or much that she can do, practically speaking. But if it's going to impact her more than that 10%, she then may be able to treat this as a termination, treat it as a constructive dismissal, and leave with her severance. So if your employer all of a sudden decides they're not going to pay overtime or they're going to eliminate overtime, if this impacts you in the pocket in a significant way, now you're earning less because of that, even though your salary is the same, it's still a constructive dismissal. Your vacation was changed, or your commissions were changed, your bonus was changed. Anything that really impacts you in the pocket, that reduces your compensation, is not something the employer is allowed to do. If they do that, constructive dismissal is something you can do. And again, pocketemploymentlawyer.ca has a constructive dismissal tool there that allows you to find out if, in fact, you've been constructively dismissed.
And with all these things you mentioned, the pitfall of letting it lie?
Well, there's a couple of pitfalls. One of the biggest ones is now you've agreed to it. Now you're stuck to those terms of employment. Now you're making less money, and if the employer doesn't bring you back to the way things were, you're stuck. We talked about that right at the top of the show. But the other thing is this. If you now are making less money and then you are let go, the severance that you get is going to be calculated based on what you were making at the time of termination. So you could be losing out on severance as well. That's why it's so important not to accept changes to terms of employment, at least now without understanding what it could mean.
Don't give away your rights ever. At least make that phone call first before you let any of this happen and reach out. It really is simple to solve these problems. Again, 1-855-821-5900. help@employmentlawyer.ca is the email address we use. We've also referred to terminationquestions.com a couple times. And that Pocket Employment Lawyer, it's like right in your pocket. You have it 24/7, as mentioned. Absolutely free. It's anonymous. And man, the knowledge on that thing is unbelievable. So check it out, if only for interest's sake. pocketemploymentlawyer.ca. And we'll catch you next time on the Employment Law Show. Thank you so much for sticking around with us.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.